Hi, I'm Brian Brown, and this is my series on structural racism in the United States for the East Hampton Public School District. So, in the last lecture, we talked about the idea of the new Jim Crow, that this current era that we're in, if we're looking at different historical eras as far as structural racism in the United States goes, that this era is about mass incarceration. And what we're seeing is that there's a huge disproportionate amount of people of color who are in some form of supervision of the criminal justice system, whether that means that they're currently incarcerated in state or local jails or federal prisons, so on and so forth, that disproportionately people of color are find themselves in supervision. This doesn't just have to mean incarceration, it can mean probation, it can mean parole, etc. And so last lecture I talked a little bit about how the basic rights that have consistently been denied to African Americans, the right to vote, the right to serve on a jury, and then many other of the rights of society are being denied to people who have been convicted of felonies in the United States. And so the next two videos are going to look at two parts of that. Today we're going to look at what law enforcement has to do with that and the discretion that police officers have and how bias, conscious or unconscious, has seeped into that. And so there's more of a focus on law enforcement against people of color than white people. Next lecture we'll talk about what happens in court with all that. Okay, so quick look at sort of the new Jim Crow and law enforcement. So when we're talking about an arrest, of course you need evidence to arrest somebody. And if you're going to charge somebody with a crime, there are elements to that crime, so on and so forth. I'm not going to be able to do a whole criminal justice lecture here, but here's a lot of what we're going to talk about today comes down to the Fourth Amendment. So the Fourth Amendment to the Constitution is protecting the right for people to be secure in their person, in their house, in their papers and affects from unreasonable search and seizure. So the sort of big phrase from the Fourth Amendment is unreasonable search and seizure. If the government is going to search me, if an agent of the government, whether that's a police officer or whether that's a federal investigator, etc., if they're going to search me, it had better be reasonable. Remember that the people who wrote the Constitution were trying to protect against tyranny. And what they didn't want was for the federal government to be harassing people, targeting people that disagreed with the government, or targeting people who, for whatever reason. The idea is that a tyrant can come to power in politics, no matter what kind of system you have. And so the idea was that they really wanted to limit the power of anybody who's in charge of government in case they were tyrannical about it. So the Fourth Amendment protects me against unreasonable search and seizure. Okay? So it has a few provisions in it. First of all, there has to be probable cause. So if you are going to search me, search my home, right? Search my car, search my backpack, whatever it is, all right? The Fourth Amendment says that you have to have probable cause, all right? And what that means is that the officer believes that I probably broke the law. Not that I might have broken the law, not even that I 51% maybe broke the law, okay? But that I probably did. It's a really high standard, okay? Now, the way that evidence and search and seizure goes, a basic thing for you to understand is that if evidence is illegally obtained against me, then anything that followed after that in a a criminal investigation has to be thrown out. It's called the fruit of the poison tree. All right. So if I'm walking down the street and I have a rocket launcher in a bag, and I'm not supposed to have a rocket launcher. If the police discover that I have a rocket launcher, and then that leads to a further investigation, and I've got a garage full of rocket launchers, all right. But it turns out that the procedure that the police used was illegal in finding that first rocket launcher. They can't use any of that stuff against me. All right. All of that evidence is gone. Anything that sort of follows that. All right. Now I can see where you might be like, well, I had a rocket launcher. I should be in trouble for that. Well, this is how important it was to the people who founded our country, who wrote our Constitution, to prevent against tyranny. Okay, the state has enormous amount of resources. All right, the state has a lot of money that they can spend and to try to catch me with my rocket launchers. All right, they just have to follow the rules. All right, as long as they follow the rules, that they can put a whole bunch of people on this investigation, and they have attorneys who work for them. And I'm going to go to prison for these rocket launchers. But the idea is that if the police don't follow the rules, all right, then it's all thrown out. Okay, and I really want that to sink in for you. All right, somebody who broke the law, you want that person to be punished for that, right? That's a functional society, it sort of works that way, right? But the founders of this country were so determined to prevent a tyrant that they said, you know what, we don't, if people are going to abuse the law, if they're going to go against these protections that we put in, then they can't use any of it. Okay, that's how much they cared against preventing a tyrant from coming to office. Right? Perhaps I'm belaboring the point, but I feel like it's an important point. Okay, so probable cause. All right, for them to search me, they have to believe that I probably am breaking the law, that I probably have a rocket launcher on me. All right, so you need probable cause. You need an affidavit. You need a sworn statement by somebody. All right, saying basically, Brian Brown's got a rocket launcher. He's going to have it in his backpack. He's going to be walking down the street. You got to name the place. You got to name, what's being searched for, and so on and so forth. All right, and that's it. That's how this thing works. All right, so you have to get a warrant to search me. That warrant, so a judge has to sign that warrant. It has to be based on probable cause. So the police officers have to talk to a judge, and they have to say, I believe that Brian Brown probably has rocket launchers, and we need, that's illegal. And they need a sworn statement by somebody. All right, my neighbor's like, hey, I just saw Brian Brown put a rocket launcher into a backpack, and now he's walking up the street. All right, okay, will you sign this thing that says that you saw that? Yeah, absolutely. People shouldn't have rocket launchers. They shouldn't, right? So that's how it works. All right, and for a really long time, that's just how it worked, or at least it's how it's supposed to have worked. Now, there are all sorts of ways that you can search without a warrant, and that's kind of reasonable. All right, so if my house is on fire and the fire department comes and they're putting the fire out, and they end up in my garage and they're like, whoa, there's a bunch of rocket launchers in there. All right, they didn't have a warrant to find that, but that's what's called exigent circumstances. All right, there was a fire, the fire department was here. All right, they found those rocket launchers. It's a good thing those things didn't go off in the fire. Right? There are all sorts of provisions for it. All right, motor vehicles for one. All right, because a car can move. That's what a car is supposed to do. You don't always have to wait for a warrant to search a car. Anyway, there are a lot of, if things are in the plain view of an officer, stuff like that. And what we see basically over a big chunk of the 20th century is that there are a lot of laws that pass that sort of chip away at the Fourth Amendment. Okay, so the idea that if I throw something out, once I throw it out, that's abandoned property. You can search that without a warrant. And so somebody put their trash out by the curb. A police department came through. They pretended to be picking up the trash. They picked up that specific trash, and they found drug paraphernalia in there. They busted the person. Anyway, so there are all sorts of cases like that where we see the Fourth Amendment sort of get chipped away at. Probably the most significant case that limits the Fourth Amendment, my right to be secure in my persons against unreasonable search and seizure, was the 1968 case of Terry versus Ohio. And I want to talk a little bit about Terry versus Ohio to give you a little bit of background. Okay, so here's the story. There's some police officers. They're what do you call it? Like undercover. They're plainclothes police officers, and they notice some suspicious behavior going on. What they see a guy who sort of walks up the street and he's like looking into a jewelry store. It's the middle of the day. Jewelry store's open. Then he's kind of going back to somebody else. He's talking, and he's sort of going back and forth. And it looks to them, these are experienced police officers, looks to them like there's somebody who is casing a joint, basically, that they're looking for a good time to go rob this jewelry store. Now, a daylight robbery of a retail establishment while there are people in it, all right, tends to happen with weapons. Okay, so you can't just walk into a jewelry store and be like, give me all your jewels or I'm going to be mad at you. All right, typically, somebody comes in, they pull out a gun, a weapon, or something like that, and they say, hey, give me the jewels or I'll shoot you or I'll hurt this person, right? So these police officers are sort of watching this happen, and they're like, we got to do something. It looks very clearly like these guys are going to rob the store. Now, if they were going to follow the letter of the law with the Fourth Amendment, they would literally have to wait until the people walk into the jewelry store and pull out their weapon before they can do anything about it. Okay? But instead, they stop the people, they talk to them, and they're able to, their suspicion is not, it continues to be raised. So they're suspicious that they're going to rob this place. They talk to them. They continue to be suspicious that they're going to rob the place. And so they search the people, and it turns out they have guns, and it looks like they, have the intent to rob this jewelry store. And so the case goes to the Supreme Court, and sure enough, the Supreme Court says, yeah, that's a reasonable thing. And so they set a new standard. And so the idea of a stop and frisk or a Terry stop starts with this case in 1968 and has a new standard. Okay? And so, and again, you hear about this, it sounds very, very reasonable. All right? It would be stupid for the police officers to have to wait for the person to pull out a gun in a crowded place and hope that they can intervene before they can do anything. Okay? So here are the standards of a stop and frisk. So you don't need probable cause to stop somebody, to talk to them. You need what's called reasonable suspicion. Reasonable suspicion, so think of probable cause as, it really means like probably. Like there's like an 85% chance that somebody is doing something illegal. All right? Probable cause is hard to prove in court. And police have to show that they had probable cause if they're going to get a warrant, so on and so forth. All right? Reasonable suspicion is the new standard by which a stop goes. All right? You only need reasonable suspicion. Reasonable suspicion is basically like, based on the experience of the police officer, all right, it's more likely than not, like this is a 51%, that somebody might be involved in some criminal activity. Okay? And so a stop is a stop. The police say, hey, I'd like to talk to you for a minute. All right? I'd like to ask you some questions. And so this new provision is based on Terry versus Ohio. All right? Now, the police officer that can then sort of ask somebody some questions. All right? They can choose to answer them or not. They don't have to answer them. All right? The Fifth Amendment says that you don't have to give any incriminating evidence against yourself. You don't have to talk to the police at all. A frisk is the next level. A frisk, again, you need to have reasonable suspicion. The police need to be searched, and a frisk is set up specifically in Terry versus Ohio for a weapons search. And what is a frisk? A frisk means that you're patting down the exterior of people's garments to make sure that they're not holding a weapon. All right? And so the reasonable suspicion, again, that you have to prove is not probable cause, reasonable suspicion, all right, is that in these circumstances, it's important to determine whether the person has a weapon or not. Okay? So the idea that you can pat somebody down to have a weapon, it depends on the circumstances. All right? In this case, a daylight robbery is just, it's more likely that people are going to have a weapon than they're not. And so, therefore, they're patting them down. But this could be a situation where if I'm a police officer and I'm stopping someone and it's the middle of the night, there's nobody around, right? I may choose to sort of pat them down to make sure that they don't have a weapon. Because it might be more likely that they would use a weapon in that situation than if it were in a crowded place, et cetera, et cetera. Okay, but the important part is that this is the discretion of the officer. And discretion is the challenge here when we're looking at structural racism, because everyone has unconscious bias. Some people have very conscious bias. All right. Again, I don't mean to say that nobody's walking around racist. All right. But even people who identify as really trying to understand these issues and maybe very actively anti-racist in their life, there are still unconscious biases going on in their heads. And so when we open things up for discretion of police officers and who they are going to stop, who they are going to frisk, so on and so forth, it becomes very quickly, they're able to sort of stop and frisk in a lot of situations, okay? And so we see again and again in stops, in frisks, that people of color are stopped much more often than white people, statistically, even though people of color are proportionally in society a much smaller percentage of the population than white people. And so basically all that officers have to say is, based on my experience, this kid looked like a gang member, or this person looked like a drug courier. You want to fall down an interesting rabbit hole of like law and case law and stuff like that. Look at how the law has defined the profile of a drug courier. All right, you can the way that it has been chipped away. Just Google it. Drug courier profile, Supreme Court cases or legal definition. Somebody walking through an airport can be profiled as a drug courier because they have short hair, they have long hair, they're dressed too fancy, they're dressed too sloppy. I mean, it is. You can profile anybody you want when it comes down to it. And unfortunately, that's what's going on, is that certain groups are being targeted. We're talking about structural racism here, all right? I don't have time in this series to even begin to discuss the statistics about stops, all right? But, one really great thing that you can look at is just stop and frisk statistics in New York City. Under Mayor Bloomberg, very, very clearly documented staggering statistics as far as young men of color being targeted versus other white people, et cetera, et cetera. The statistics are overwhelming. All right, you don't have to take my word for it. Just whatever. Throw a dart at the internet, you'll hit a study that will shock you. Okay, so by the way, when someone is being frisked, there's a thing called the plain field doctrine. So police officers are trained to frisk for weapons, and if they find something that feels like a weapon, then they can seize it. But they're also trained to feel for things that might also be illegal. But it has to really feel like it. So in other words, if someone has something that feels like, I don't know, like a crack pipe or a syringe or something like that, which, you know, hopefully somebody doesn't pat a syringe. That would be really dangerous. But they've been trained to be able to seize that. All right. But if somebody has something illegal in their pocket and it doesn't specifically feel like something illegal, they have scalped concert tickets. I don't know. Concerts aren't really happening right now, but the police couldn't seize that, right? Because they can't tell from the outside of your clothing that's an illegal concert ticket, whatever. Okay, so what this leads to is not only an enormous amount of, if people of color are being stopped, not on probable cause, but on reasonable suspicion at a much higher rate than white people, then of course we are going to have people entering the criminal justice investigation situation at a higher rate as people of color. This is structural racism. Okay? If police find a black man more threatening than a white man. What this also though means, because a lot of people aren't in possession of paraphernalia, aren't breaking the law, what this also means, and it's something that I haven't discussed a lot here, but just the general exhaustion of walking around being distrusted all the time and being harassed and being stopped day after day after day from just simply existing, trying to walk down the street, trying to drive down the street. We'll talk about driving in a second. And just getting this message constantly that you are mistrusted. All right? And man, I don't have a lot of time to go into the psychology of that right now, but I used to hear a lot of people complain that people were being crybabies for complaining about being profiled or so on and so forth. But I'm seeing a lot of those same people complaining about stuff right now. All right. I don't know, I guess I'm gonna step away from that conversation. I don't need to go there right now. All right. Here's what I want to say. Because we all have implicit bias. All right. Because we all have deep in our head this subconscious beliefs about different people based on their race and so on and so forth. All right, and because there's also explicit bias and prejudice and racism and stuff like that. All right, as it turns out, people of color get stopped more, and if you're stopping people more and you're searching people more, then you're more likely to find stuff on them, and people are more likely to get drawn into the system. Okay. I want to talk a little bit about traffic stops, so just like with stop and frisk, there is just overwhelming evidence that people of color are much more likely to be stopped in a traffic stop and questioned by police officers for stuff that doesn't have to do with the traffic stop. It's what's called a pretextual traffic stop. All right, a pretextual traffic stop is a situation where a police officer pulls somebody over for a traffic violation. Okay, so police officers have a couple different jobs. One of them has to do with the roads and stuff like that, and that's all. That's like civil infractions and stuff like that. It's actually a different category of the law. But when a police officer stops somebody for some sort of traffic violation, all right, they are able to then investigate and see if there are any criminal activities that are going on. Because a motor vehicle is a little bit different than a house, all right. If you need a warrant to search my house, all right, but you don't need a warrant to search my car, all right. And there are some specifics about that, and I know, you all listen to your Jay-Z and you know about the trunk and the glove box and all that, but the point is that in order to search a vehicle, you don't necessarily need a warrant because you don't have time to wait for a warrant because a car can drive away. And so traffic stops are a little different. And so, again, the statistics really bear this out, that people of color are stopped more than white people pretty consistently. When people decide that they're going to collect the data on this, that's what they find. And, one of the things, if you're sort of learning about racism in America and stuff like that, if you listen to people of color, parents always talk about having the talk with their kids. And there's a certain point where you have to sit your kid down and you have to say, look, the world is a lot more dangerous for you than it is for some people. And that if you're driving a car, even walking down the street, walking through a store, so on and so forth, because there is prejudice, you are more likely to be stopped. And there is, this level of violence that happens, that people of color are feared, and there's a higher portion of violence against you, small child, than against that, your neighbor who's a white kid. It's a very different way to live in society. And so people, talk a lot about the idea of driving while black. All right. So the idea of a pretextual traffic stop is this. Police are, out there looking for people breaking the law. We talked a little bit about this prioritization of the war on drugs and so on and so forth. And so this idea that the police can stop you for a minor thing that can lead into a much larger criminal thing, people have challenged that. And there was a case in 1996, Wren versus the United States. It's WHREN, I believe. And that actually challenged the idea of pretextual traffic stops. And what the Supreme Court unanimously decided was that the police can use any traffic violation to then roll it into a criminal investigation. All right, so here's how it works. Police pull somebody over because their brake light is out. All right, probably a lot of us have been pulled over for something like that. Your sticker's expired or something like that. Whatever it is. So police pull you over, and they're gonna come talk to you. And if you're like intoxicated or something, they're gonna maybe be able to tell that, and that can roll into a whole thing. All right, but there are all sorts of ways that this can sort of turn into a greater investigation. If the police want to figure out how to search the car, in many ways they're going to be able to do that. So a lot of this has to do with consent. It's way easier to get consent to search somebody, whether it's a Terry stop or whether it's a pretextual traffic stop, than it is to actually come up with reasonable suspicion and be able to sort of say all that. So the police may just ask if they can search the car, or they may ask you, do you have anything illegal in the car? And what they find is, a lot of people will consent to a search. Now, this is the level of authority that police officers have over people and the way that people respond to authority. It's a fascinating psychological topic, right? Maybe you know that I teach psychology as well. If you look at something like the Milgram experiment, where people in authority, told people to do stuff and they did it even though it was completely unreasonable. The Stanford prison experiment would be another case where people are willing to give up their own authority over themselves to authority figures. All right. So if a police officer asks you if they can do something, the idea is that you should be able to say no. All right. But a lot of people, first of all, don't know that they can say no to a police officer. All right. The police officer doesn't have to ask in a way that makes it that really sounds like a question. All right. But as long as it is a question, if you consent to a search, then the police don't need a warrant. They don't need reasonable suspicion or probable cause. They don't need anything. At which point, anything that they find can be used as evidence against you. All right, and so the issue here is that in a situation where this authority figure, right, who's in this very impressive uniform, and they've got a gun, and so on and so forth, and they have you detained there, in which they might have your license in their possession, at which point you can't drive away. Well, actually, that technically is different. That's technically an arrest. I wish I hadn't brought that up. All right, because you can't legally drive away in that case. It's a different set of laws. The point I'm trying to make, though, is that often people consent to a search, and even though technically they could have said no, they don't necessarily know that they could have said no. And so pretextual traffic stops, stops with a stop and frisk, so on and so forth. These are ways that people enter the criminal justice system because they either admit to a crime or they have evidence of a crime on them. Okay? Now, people are committing crimes and they get busted for crimes. Like, I get it. All right? The point is that the people who are being asked about it, the people who are being targeted, are a specific group of people, and that's people of color, to a much greater extent than white people are. All right? Well, white people are breaking the law at the same percentage rate, but they're not being stopped, they're not being questioned. They also don't have to go through life being stopped all the time, being questioned when they're not breaking the law. Okay? So structural racism works on a couple ways. In a big way, right, we're talking about people like losing their right to vote for the rest of their life, going to prison and things like that, not being able to get a job, not being able to get public housing, all right? But we're also just talking about the structural racism of, getting in your car and driving up the road and not being stopped because the police think you're a criminal. Maybe you've had the experience, maybe our first car was kind of a crappy car. Maybe you got pulled over more often with your crappy car than you do with your nice new car if you got a nice new car, all right? Or maybe you don't look like the kind of person who should be driving a nice new car. Maybe you get stopped all the time because you're a nice new car, all right? So, there's all sorts of ways that we might gain a little insight into this, all right? But the point is that the discretion of police officers on who they stop, all right, who they search, all right, and then the erosion of these protections that, again, were added onto the Constitution by the framers to protect us against tyranny, have been stripped away, giving enormous amount of authority to police officers, okay, which in many cases might save lives, all right, but which have been shown through enormous amounts of research to specifically target people of color, all right, which results in, it's that sort of first step into the criminal justice process, all right, disproportionately for people of color. Okay? And so those biases that we all have, all right, so police officers are people just like the rest of us who aren't police officers, and they have biases just like everybody has biases. All right, but when you add the authority of the police in general with the erosion of Fourth Amendment protections, what we have is biased people stopping, questioning, looking for evidence in very specific places based on that bias, and therefore we have a structural, institutional system that is disproportionately punishing people of color. Okay, so that's our little introduction to search and seizure. Next lecture we'll talk about prosecution and juries and things like that. Okay, thanks for tuning in. We'll see you next time.